A very good evening to everyone and a very, very warm welcome to all of you on behalf of OP Jindal Global University, Sonipat. I am Jhuma Sen and I will be your moderator tonight for what promises to be an extremely invigorating thematic session on the law of the proletariat, social movements and law. And we do have some fantastic speakers with us who need no introduction. So I will be very brief introducing them to our audience. We have Professor Eduardo Capulong, who's the Interim Dean of CUNY School of Law, City University of New York. We have Professor Dr. Jayanth Krishnan, who's the Professor of Law at Indiana University. We also have Professor Dr. Andrew Siegel, who's joining us from the School of Law, Seattle University. And finally, we have Professor Dr. Dilip Ukey, who's the Vice Chancellor of the Maharashtra National Law University, Mumbai. Now onwards to the session, which is Law of the Proletariat, Social Movements and Law. And we are living in very interesting and exciting times. And we do see the everydayness of law all around us, from Shaheen Bagh to the farmers' protest and beyond in the context of India. But it is not just an Indian phenomenon alone. It's quite a global phenomena. So what we will try to do, it's a very humble initiative on our part, is to try and deliberate on the complex relationship of law and resistance in a world which is largely mediated by the specter of the capital. And in doing so, we do hope that this session will also try to understand and frame a theory of resistance, and also, of course, question whether it is at all possible to frame a theory of resistance, and not just really a framing of a theory of resistance, but also that of an insurrectionary jurisprudence. And we do hope to at least to probe this idea a little bit and see we will try to investigate if this radical transformative potential of social movements is actually limited not only by law's insistence of rule, discipline and categories, but also by its very dubious role in actively shaping and facilitating global capital, which is responsible for largely for anchoring and nourishing the inequalities of race, gender, sex, caste, economy, and everything, every little thing and every big thing really, which many social movements try to engage with. Along with this, the panel's humble attempt will also be to understand in some manner the shifting category of people. When we are talking about the proletariat, what constitutes the proletariat, what constitutes this, the we-ness of the people, and try to understand its slippages in legal and juridical discourse as well. We do see that in authoritarian regimes in the neoliberal global capital, which is largely controlled by law, what role does really law play in mediating these tensions between global capital and the spaces for democratic dissent? So this is really, in a sense, this is the central theme of this session. And hopefully by probing and prodding these questions, the session will also be able to explore and imagine the possibilities of an alternate legal disorder, if I may use that word, which is able to move towards movement building by disrupting laws, kingdoms, and empire. So this is broadly the sort of the thematic focus of this session, like I already said, and you can see, we do have some really exciting speakers. So I will actually now open the floor, and I will start by asking some questions. And my first question is to Professor Eduardo, and I will ask Professor Eduardo, and it will be really an honor to receive a response from him, that it has been often argued that there is no straitjacket formula to theorize resistance. And at the same time, we have seen that law and society scholarship has actually demonstrated that law really defies easy definitions and categorizations. Law is like something that cannot be contained. It's always trying to sort of move out. It's trying to go beyond narrow categories. Law defies categories. If we try to like fix law and put law in tiny little boxes, law often tries to escape and evade us. So this is the this is the teeny tiny problem that we have in categorizing law. So what are the possible ways then of theorizing a law of the proletariat or a law of resistance, when there is really no way in which we can theorize either law, or we can sort of understand or define resistance? Professor Eduardo, if you can respond to that question, or really if anyone else would like to jump in, that's also absolutely fine.
Well, first of all, thank you very much for having me in this panel. I think the question is quite central to what we're all doing. The first thing I would say is, law is a contested space, right? Especially those of us who subscribe to a pluralist view of what the law is, and not just a positivist view of it in terms of what the statutes or written laws are. And so I think here in the US, we have a very rich canon of scholarship in this area, variously called community lawyering, rebellious lawyering, right, law and organizing. And so I think there you'll find various ways that scholars and colleagues have theorized a jurisprudence of liberation. And so I think what we find in that scholarship is that, yes, it is contested space, and we are always in a liminal space as lawyers and as legal academics. And then secondly, I think law in the legal profession is a very opportunistic endeavor. And so even the promise of, liberal legalism is not really true, right? So even when we insist on what equality and what democracy means, we find that in itself is a theory of liberation, because it often goes unanswered. And so I think there's a lot there in that canon that we can draw from. And in terms of theorizing what is, I always believe that even as we fight for what's in the here and now, we always need to keep in mind the concept of law as future liberation. So it's always in the offing in the way that we relate to the social movements today.
Thank you. I think that's that's quite incisive. The manner we say law is indeed is indeed a contested space, and that actually brings us to our second question. And I would probably ask Professor Jayanth Krishnan, and that is this is also to largely take from his work as well. The relationship between social movements and law. This is indeed a complex one, and it is often argued by scholars, scholars of law as well as scholars of social movements, that social movements are limited by law, and that law does not always really allow one to explore the transformative, that expansive, radical, transformative and transformational possibilities of social movements. So how far does this then become a legitimate form of criticism of law, that law is something that limits instead of something that really that's something that frees or liberates social movements? Jayanth?
Yeah, thank you, Professor Sen, and thank you for inviting me to be a part of this. It's wonderful to see you and to be on this panel with my distinguished colleagues. So I'm grateful for this opportunity. And I think you're right. I mean, as I think about just today, I mean, December 2nd is 37 years ago. I think all of us know that it was this evening, actually, the Bhopal gas leak tragedy occurred. And so if we think about what happened 37 years ago and the tens of thousands of people who were killed, harmed, devastated, and then the movement that emerged as a result of it, both in India, but also in the United States, I think it's important for us to reflect and just take a moment to understand that what you said is so, I think, perfectly right, Professor Sen, and that is that law and I would even argue institutions have proven to essentially be real challenges for the needy, for social movements that have tried to make progress. And of course, I think Dean Capulong raised the literature on this that, I've been fortunate to be a part of for a while, the cause lawyering, the rebellious lawyering. And we do see, I think, very important developments on that front. But I think it's tempered by the fact that institutions too often, in my view, have played a really constraining role to reify the status quo. And if we think about, for example, all of you, I know, are familiar with the Bhopal tragedy, but even there is a story about what happened in the United States regarding the victims, and how really after the tragedy, what we saw were lawyers who tried to bring tort-based claims against Union Carbide in the aftermath, and that were time and again essentially met with resistance from the Southern District of New York, frankly. And this is something, as you and I have talked about before, Professor Sen, at various conferences, and I was lucky enough to talk about this paper a couple of years ago at Jindal. We look at what happened in that Bhopal litigation, and we look at the social movements that tried to essentially realize the rights of those who had been harmed. Time and again, as I say, we had the federal courts in the US block and block and block from a period of really 1985, 1986 up until 2016, efforts by lawyers, efforts by the needy to seek some type of justice. And so I think your question to me really, and this just piggybacks off of what Dean Capulong said, it really goes to the heart of what we're trying to study here, because at the end of the day, where law, where institutions are being these forces of resistance, it's going to be very difficult for social movements to make progress, even where we have inspiring cause lawyers, inspiring rebellious lawyers present.
I think, I'm really glad, thanks for this. And I'm really glad that you spoke about Bhopal, because Bhopal is the sort of the center of, has been for a very long time, the center of this kind of this dichotomy that, should we use law? Should we use institutional spaces? How much should we use it? And what really, and you said that institutions do play a constraining role, and you've worked on that, on this. I was actually also thinking, from just to sort of flag it here, that it's if you look at the sort of the current space, the public space, the public sphere as a sphere of spectacle, as a sphere of resistance. And if you look at the, if you look at our institutions, and when I talk about institutions, I'm talking, of course, largely about the judiciary. And from the Shaheen Bagh to the farmers' protest, the manner in which mostly Shaheen Bagh, the farmers' protest, it didn't really, the court was not that involved, but with Shaheen Bagh, it was quite, interesting, the manner in which the court just, jumped onto it, and almost sort of was this this anti-resistance, force of anti-resistance. So that's a question that might be sort of discussed or taken up during the Q&A session at the end. But thanks a lot for this. I actually want to move to the next question, because this all seems very very grim, because if the institutional spaces are not really allowing us to speak with each other, or really building, they're not facilitating making resistance or building movements, then where do we go? So my next question is actually to at Professor Andrew Siegel, and so on a more joyful note, what in your opinion have been some of the most dynamic and successful social movement that, that successfully engaged with law and played a key role in creating a community of consent for a social movement to thrive and grow. So we are trying to sort of, unlearn Bhopal and, its aftermath.
Well, thank you so much for having me. Thank you to Jindal for organizing this and for including me. I feel honored to be brought into this conversation. I'm not myself a social movement scholar, though certainly read in the field. My experience is in American constitutional law and legal history. And I'm not going to be the sunny voice that you asked me to be. My comments are going to echo and reflect back on the comments of the last two speakers. When I hear Professor Krishnan speak about the constraints of law and the constraints of institutions, and when I hear you speak about kind of the anti-resistance power of the courts, that resonates in everything I read, everything I write, everything I think about, today, in the past, in other time frames. I do think implicit in the question that you asked Professor Krishnan is, and his answer is, what is the alternative? To say that law is constraining and institutions are constraining is a starting point, right? The constraining power of law will work upon people whether or not they embrace the legitimacy of the law as an initial matter. The kind of social consensus, the power of the notion of law, the inherent legitimacy that in most systems, certainly US systems, at most times, and not at crucial moments, but at most times, the institution of the judiciary has, the ability of capital and other powerful interests to control them at crucial moments, means that the force of law is going to come down on social movements and constrain social movements, irrespective of the amount of buy-in from the movements. So in the absence of being in a rare transformative moment, and societies have them, where systems collapse in and of themselves, or where contradictions or divisions among elites allow real moments of opportunity, the real only choice is the literature, is the approach in the literature that Professor Dean Capulong suggested, which is a kind of interstitial, pluralistic, opportunistic use of legal sources, exploiting opportunities, appealing to common norms in ways that traditional elites didn't expect them to be used. In the language of some of the other questions that we're going to talk about later, claiming part in the we-ness of we the people, despite the fact that others want to exclude you. And as a result, to get back to this question, what we end up with is a world of compromise, a world where in order to succeed, except in rare transformative moments, social movements and rebellious lawyers are always sacrificing something for each victory. So when I think about the movements that have been successful, whether it's populist movements to class-based or reformist movements in the late 19th, early 20th century in the US, or I think about different groups in the rights revolution of the last half century in the US, whether it be the civil rights movement, whether it be the movement for gender equality, whether it's LGBTQ plus equality, all of those movements have won legal victories and claimed a little bit more space in We the People, but they've been tempered and constrained by the institutions. They've been co-opted around the margins. Agendas have been shifted. The collective power of the social movements have been muted to claim those victories. And I think it's a structural negotiation, or it's a structural reality that we're dealing with here.
Thank you, Professor Siegel. I was looking for a very bright and hopeful response, but I think we are all kind of down in slump when it comes to discussing or thinking about the sort of the radical potential of law and its limitations. I will still try to get this get this response out. But my first question is to Professor my first question to Professor Dilip Ukey, and perhaps this will again take us down to another spiral, and that is this question is about this the notion of we-ness. When we are talking about this we in we the people, there is who is this we that we are talking about, because even if you look at the, and if you, for example, if you look at the history of our own our Supreme Court, our higher judiciary, the people, the Supreme Court defined, gave a definition of people in the judicial 80s, and that definition of who really was the people or who really was the we, that kind of really that changed almost like 180 degrees later in the 90s with all development, large scale projects and so on and so forth. So this so just to sort of poke around this idea of we in we the people, and this the community of consent that this this we the people creates, it is argued, and it is possible to see why this is often argued, that there is it tends to generate some sort of a slippage between the promise of we, because it is indeed a very powerful word, we, and there is a threat of it as well. Who is this we? What is it speaking for? Who is it speaking for? So this majoritarian we-ness, as we are seeing now, it has been actually demonstrated that it has historically oppressed marginalized communities. So in what manner can the epistemic communities of law, all of us really, how can they navigate these tensions between the in the slippages of we, which is to say the threat of the promise of we and the threat of we? So this is my question to Professor Dilip Ukey.
Thank you. Thank you for inviting me and including me in this panel, and thanks for the question. Yes, it is true that this we-ness has its two different connotations. As we say that one is India, another one is Bharat. So that diversity, India and Bharat, divide between India and Bharat, that is a harsh reality which exists. Nevertheless, when we talk about we the people, that inclusiveness which is there as ingrained in the preamble of the Constitution, Indian Constitution, and then the responses which are given by laws as well as the social movements. As in between, I think reference was made about some marginalized sections as well as the social movements. That's true, that unless these social movements occur, unless this struggle, as we know, the Indian society, which is a stratified society, maybe based on religion, race, caste, gender, so on and so forth, regions even. So wherein, that divide between have and have nots, that's what we are talking about today, the law of the proletariat. So whether it is really in that sense the law of proletariat, but yes, to some extent, the success achieved by the social movement, say for example, to my mind, the enactment of Right to Information Act, that itself is the product of social movement, initiated in Rajasthan. And not only that, when you look at the whole gamut of the Dalit movement, spearheaded by Dr. Ambedkar in 1920s, the temple entry movement, then the water movement, the pond in Maharashtra, wherein he launched that agitation. So right to water, right to worship, all these things have been culminated ultimately in framing certain provisions of the Indian Constitution, particularly even Article 17, abolition of untouchability, and then subsequent enactment of some legislations. So nevertheless, even after now, we are celebrating 75 years, but that divide that does exist between majoritarian and the other side, the India, as I said, and as people say, that is Bharat and India, the divide is there. And particularly in this pandemic, that was much visible. The issues posed by the initially in the first wave posed by the migrant workers, their problems, even though the act is there, I believe that is the Migrant Worker Protection and Rehabilitation Act 1970, which is there, but that was either ignored or neglected. The duty which has been primarily of the employer. So there are all these issues which are there, but that we-ness really, that inclusivity which is rather expected, that is not yet, because it is what I feel that these are the mindsets. Though science and technological advancements which have had occurred, education on one hand has developed, nevertheless those mindsets which are required, those consciences which are required, that those mindsets still, the change, when we talk about a change, when we talk about the transformation of the society, the transformation or the change not only in terms of the material development or material growth, but rather that is a change of attitude, change of conscience of human being. I rely and fall back upon again the preamble of the Constitution. Usually we emphasize upon the justice, liberty and equality. I do not want to dwell upon all those things. However, we either tend to ignore or neglect the notion of fraternity and assuring the dignity of individuals, which has been translated into the fundamental duty under Article 51A, Clause E, which talks about the common brotherhood. So in this sense, that duty, which is rather usually we are possessed with our rights as fundamental, but duties which are also fundamental, we tend to ignore or neglect. So how that we-ness would come? So it is not only for the state, it is not only for the government, it is for really we the people of the country, which need to ponder upon it, we need to adhere about it, and then only that we-ness will come. And that's why wherein the social movements play a vital role, a pivotal role for the social change and social transformation.
Thank you, Professor Ukey. I think we can, probably discuss this further. Take this point about sort of the space between rights and duties further in the Q&A session towards the end. I will just quickly move to, because I'm mindful that we are we are running out of time, so I'll quickly move again back to Professor Eduardo Capulong, and I was just thinking it might be a because when we are thinking of social movements, or when we are thinking about revolution or resistance, all these need a language. There's the language of articulation of a revolution or resistance or social movements. That is a very important aspect. That's a very important facet of any form of resistance, really. So when transnational social movements, when they gain a local character, and on top of my head I'm thinking of CEDAW and the women's movements actually in plural in India. So when these transnational social movements, when they sort of migrate and they gain a local character, and sometimes local characters, local struggles, they also expand and they migrate to transnational spaces. So this is like always the movements are kind of moving from one space to another. There is this constant migration, and when we think of migration, when we talk of migration, we never really think of migration in that sense, but movements do move in that sense. So what difficulties should law navigate in such cases to vernacularize such movements and their vocabularies, and in what manner really in what manner can vocabularies of universal human rights, for example, that whether they can they be translated by law locally and vice versa. And I can, on top of my head, I can think of two really interesting sort of cases, if I may use the term. One is the manner in which Dr. Pooja Parmar, she uses the sort of the example of the Plachimada struggle to show like how when a local movement gained a transnational character, really a global character in that sense, it lost much of its, it lost much of its character, and the participants and the actors of that struggle were not really very happy with it. And one of the reasons was that there was a gap in translating of the movement. And the other example that I can think of is the Niyamgiri judgment, where this idea of this this modern law, this is very central to it, and language and discourse of law, discourse of rights, not just discourse of law, but discourse of rights is very central to that judgment. So on top of my head, I was thinking of these, but generally, if it will be really useful, it will be helpful to our audience and especially to our students if we can talk about this, this bit about vernacularization of movements. Thank you.
Well, and another example is the use of the language of human rights to justify the so-called war on terror, right? There's a recent book that came out from a colleague, Filipino colleague in Australia, looking into that. So I think it's really important to be talking about how the universal language of human rights, say as mediated by international organizations like the UN, can serve, as Professor Krishnan was talking about, can serve as also an institutional constraint, right, to the kinds of local movements that we see that have an international dimension. I mean, of course, I think about, recent example of an international movement with local kind of local dimensions is the movement around climate change and how that's both kind of a local issue, right, and also a global issue. I mean, I think for me, just given the conversation that we're having, what Professor Ukey is saying, Professor Siegel and Professor Krishnan and Professor Sen, to me, the law of the proletariat and law is such an abstraction, right? It abstracts who we are, right? Who we the people are. It abstracts power and violence into these supposedly, at least in the liberal legalist context, these supposedly neutral norms. And I think that ultimately what we're talking about in terms of vernacular and in terms of international dimensions of struggle or even revolution is that one is we need to understand that, as Professor Siegel was saying, that any movement is going to have to deal with the law somehow. It's going to have to deal with trying to extract from the state certain concessions. But as we do that, and as we work with social movements and organizations and folks who are in this struggle, we need to kind of have a much more strategic perspective on the limits of the law as currently existing and kind of the dominance of capital in the kinds of reformist or revolutionary struggles that we're involved in. You see that, right, in every struggle that we've been involved in. I'm not familiar with Bhopal, but certainly the civil rights movement, right, the movement around labor rights, workers' rights movements in the 30s, movements around women's rights to choose, right, the Supreme Court just heard arguments around that. The limits of it are quite liberal, right, and it's always a struggle within those coalitions as to how far to go. But when we don't go beyond the victory in court or the victory in legislature in order to have a much more strategic and radical imagination of what we want, then yes, at some point, right, there's going to be a blowback, and you take away the labor rights, you take away the right to choose, right? You take away, the welfare state, you take away civil rights, and you don't really strike at the heart of the problem, which is why is this happening, right? Why do we have to fight these every 10, 15, 30 years? Which goes right to the heart of, well, then we need to imagine the law of the proletariat, right? Which is to say, just admit, right, that law is really a mask in terms of exercising power. And here we want to exercise power over capital, right? Over racists, over, and that's always a challenge, I think, in the liberal order is how do you do that without being utilitarian in the way that you practice your craft.
Thank you, Jin Kaplan. I think this was a fabulous response, and I will just I will move actually to Professor Siegel for a bit, because this conversation on global capital, you raised this, and earlier Professor Andrew Siegel also raised this, and that is to sort of hold on to this idea that it is argued that global capital, because global capital does have a norm setting agenda as well, and global capital, when we see global capital global capital does global capital on the one hand, and the narrowing of progressive political possibilities on the other hand, these tend to limit the space for democratic dissent, and especially in authoritarian or semi-authoritarian spaces where institutional structures have either collapsed or they're about to collapse, and in order to serve authoritarian regimes. So is it really is it really possible to sort of imagine a law of the proletariat in these contexts? And if it is indeed possible, then what would that really look like? Because if your institutional structures have collapsed, what space do you have to articulate resistance in the manner in which you would you were supposed to? So that's that's my question to Professor Andrew Siegel.
Well, I appreciate the question, even though it's a hard question. It is, I think part of the answer starts where Dean Capulong left off, which is that shush my children out of the way. Guys, go. In the world of Zoom we live in these days, in talking about what a law of the proletariat would look like, one of the tasks that has to be before us is, in Dean Capulong's words, unmasking the lack of neutrality in the law, right? You don't have to be hostile to law as a concept, but you have to be hostile to this liberal notion that capital and others have developed, that law is inherently neutral, that law is not serving the interests of capital, that law is not serving the interests of other power hierarchies. So that is kind of the first and central space for contestation. When law comes down on movements, when law has devastating social consequences, personal consequences, you don't take that as just the brakes. You call that out as an act of power and an act of violence. I think that's got to be a starting point. If you conceptualize and theorize about law as or about the law that exists at any one moment in any one society as going hand in hand with the power structures there, particularly the economic power structures, then it does create intellectual space for thinking about, well, if the power structures were different, if the economic structures were different, what system of law, because law is now in quotes, would you create to enforce those very different norms? I think that's half of your question. The other half of the question is a much more practical question of what do you do when the threat of physical violence is real, when kind of the mask has come off to some extent of capital or other power hierarchies, and you're in a world in which you're either in an authoritarian regime, or you're starting to see people use authoritarian tactics, or the threat of violence is kind of implicit in the actions of the power structure. And that's a different conversation that I'm almost not equipped to have, because that is a conversation that really comes down to facts on the ground. It comes down to the possibility of success, the tolerance for physical risk, calculations about just how willing to use violence authority is, and that's a really scary space to be in, and lots of the world is in that space at any given time. So it's kind of a sobering check on the kind of high philosophical conversation we're having here. And that's about all I can say.
Thank you, Professor Siegel. I'll actually, I think I'll shoot my next question to, Jayanth, because I really want to get a nice sort of, like a less depressing feel out of this, this panel and this discussion, because, we are, it seems that we are doomed. There is no way out. We are doomed with law. I actually wanted to ask, and because of your work on cause lawyering, I know you've done a fair bit of work on on that. What does in this grim sort of scenario, what will what does social action lawyers, because they are increasingly being targeted by states. I mean, I should not even say social action lawyers, I should probably say just lawyers. I mean, just for the act of lawyering, people are being lawyers are being incarcerated. So in such a scenario, what is really the future of cause lawyering, in these contexts? Is there a way out? Can we really move, can we really, make movements, build movements around lawyering? Law is bad, but lawyering may have some possibilities. That is what I'm trying to say, perhaps. What is that possibility, and can we do something?
So thank you. And I think this actually goes back to the opening comments by Dean Capulong, and when he referenced the literature on rebellious lawyering, and when he referenced the literature on social movement lawyering. I mean, I think we can take inspiration, frankly, from what we have seen in the past and what is actually happening today. And, one of the great things about being in a law school, like all of us are here on this panel, is that, we're talking to the future leaders of the legal profession. And I know from the institutions that each of my fellow colleagues on this panel are at, I know how much that training our students to be not just legal actors, but also to be thought leaders, to be people who are going to be out there in the political world, in the business world. That's really part of all of our missions here, right? As we're thinking about how to train the next generation of legal professionals. And I think it's sobering because on the one hand, I don't think we can ignore, at least here in the United States, but globally as well. But we can't really ignore the last 4.5 years and the really devastating impact that we saw in the United States from that the previous administration had on so much of what we are all really concerned about. But I do take inspiration from the students that are in my classes, from the students I see doing wonderful work. And because what we know from the literature is that, smart social action lawyering doesn't just involve winning in court. It doesn't necessarily mean getting those wins. It also means rhetoric. I mean, Michael McCann many years ago wrote this fabulous book called Rights at Work about the pay equity movement in the 80s and 90s. And it was such a wonderful, brilliant book because what he talked about was how the social action lawyering that was occurring, the cause lawyering that was occurring, was done by these lawyers who were thinking, how do we change the rhetoric? How do we change the culture? And if we can get a win, great. And if we can get, wins, great. But if we can change the imagination, to use Dean Capulong's word there or earlier, if we can change the imagination of how we're thinking about struggle, that will have an impact beyond the particular case at hand. And, of course, that goes back generations, that sort of strategizing. It didn't just occur in the 80s and 90s. I mean, we see that occurring in different eras, and we've seen that occurring in different contexts. So I know that, we've been very somber in a lot of our conversation, and I think rightfully so, especially given the last 4 years that we've had to endure. But I try to be a glass half full type of person, and I'm hopeful. I am hopeful, and I'm hopeful because of who I see in our classrooms and the students that we're teaching. And to that extent, I think that there is some positive that we can look to.
Thank you, Professor Krishnan. I also feel a little hopeful now because we have been, it seems that space for democratic dissent is shrinking. It's pretty much globally. So that brings me to perhaps the last question, and we don't have much time because we have some audience questions as well, which we need to respond to. So Professor Ukey, if you could very quickly, if you could just sort of, wrap this session by probably by just sort of articulating how jurisprudence of resistance will really look like. You spoke about the RTI, the Right to Information Act, the movement towards getting a Right to Information Act, and perhaps there are others. And what, is there anything, is this something that kind of connects or binds, all these movements to assert some sort of some sort of a notion of jurisprudence of resistance, or an insurrectionary jurisprudence, if I may use that word. Thank you, Professor Ukey.
Thank you. Yes, not only Right to Information Act, even Domestic Violence Act, enactment of Sexual Harassment Prevention Act, and there are other instances as well. Even rather the human rights movement, or even the movements of Narmada Bachao Andolan, then Chipko movement, there are various farmers movement or laborers movement. Ultimately, the aim is the social change, and change in human interactions, change in human relationship, and ultimately change in social, economic, and cultural, even institutions, even legal institutions. That's why ultimately, law is nothing but a kind of a product of the social movement, we can say. And that's why rather it could be labeled as, from that point of view, loosely, if it is permissible to say so, law of the proletariat from that context, or from that point of view. But yes, in all these years, everywhere, unless someone takes an initiative, someone leads from the front, it is not that the whole social movement is the product of the masses. Rather, there are few leaders not in terms of what we understand as political leaders. Few leaders who disseminate the knowledge, who enlighten them, and then masses join such movements. And ultimately, these movements, as I said, culminates in a legislation, in a lawmaking, most of the time. And when we say social movement, not necessarily the agitation alone, like as earlier we were talking about the social action litigation, social action lawyers as such. So either social action or public interest litigation, as it has been evolved in India to the great extent, and for the benefit of the social, I would say, social transformation. Say, for example, the landmark judgment delivered by the Indian Supreme Court in Ishad Worker case, which tried to do justice to those workers, engaged in construction work of Asian Games. So when we talk about the jurisprudence about this, so whole process, if we may call it as a process, whole process, is the product of the engagement from many quarters from the society, the leaders, the masses, even some philanthropists, and then ultimately it results in the culmination of law. As I said, there are several instances, even say enactment of Protection of Human Rights Act, the setting up of National Human Rights Commission, State Human Rights Commission, because there were the instances of rampant human rights violations, as we know, and that's why ultimately the state, if you politically, if you want to put it in that way, has to yield to that kind of a pressure, as in a political science, the pressure groups work, for the purposes of the sharing of power, as even it is known to that even the constant power, though it is vested in the hands of the parliament, but as Professor Bakshi said, that Supreme Court shares even the constant power along with the parliament as such. So likewise, that sharing of power. So space has to be created sometime. And unless that space is created, and this space could be created by way of this movement, by way of this resistance, and by way of the sometime even agitation. Of course, the Constitution sometimes takes care, like say Article 39B and C. This is not an occasion or a time. We do not have much to dwell upon this. So, in nutshell, yes, it is the whole process which takes care of it.
Thank you, Professor Ukey. It is, it is indeed, I'm a big believer in the everydayness of constitutionalism. The everydayness of law and the everydayness of constitutionalism, the everydayness of, mostly I'm a believer in a praxis more than just theory. But I will rush because we have very little time and we have some audience questions. There are two questions. One is a part question. And anyone can really jump in. This is not because these questions are not addressed to anyone in specifically. So the first question, the first part of the first question is, so thank you for your insights, professors. During these challenging times, do you believe that globally we have been able to sufficiently manage the desired level of coordination or cooperation amongst countries in terms of social issues? The second part of this two-part question is, from your experience, could you share any instance that has proved to be a successful attempt in bridging harmony of law for dealing with such issues? This is the first question. The second question, I'm just placing it. How can budding lawyers contribute in cultivating awareness concerning the legal aspects of social movements? Do universities encompass related subjects, activities for such advancements? So these are the questions, and anyone can really jump in. Professor Capulong, you want to respond to any of these two questions? Or
I'd like to defer to my colleagues if folks have ready-made responses. I mean, I'll answer the first one. The answer is no on that first part. And as far as the third question is concerned, or at least I think a lot of our schools do offer programs and curricula that train lawyers in this realm. Not perhaps not just, I shouldn't say not just, because the areas, of course, and the field is vast. Rebellious lawyering, cause lawyering, but drawing on just the different traditions that we've had, we do offer these kinds of programs to students on how we connect with social movements and with clients in a way that's transformative.
Thank you, Professor Capulong. Jayanth?
Sure. I mean, I think one place that we've seen a huge crackdown in the U.S. Over the last 4 years has been in terms of non-citizen rights, particularly people coming and seeking asylum, seeking protections from environments that were dangerous to them. And the response over the last 4 years in particular has been quite brutal. I teach immigration law. I've been teaching it for something like 20 years now. And this is the most sobering, disheartening period in my career of watching how people who are seeking to come here are being treated. But with that said, I mean, I will hasten to point out that and I'll use this word again, I've been inspired by my colleagues in the immigration bar who have been really fighting the good fight. And they've been doing so in a very smart, strategic, coordinated fashion, not just within the United States, but working with lawyers in other jurisdictions to the best that they can. I mean, given the fact that there are limitations on resources and huge, enormous political pressures. And so I, on the one hand, don't want to minimize the devastating impact that the government has had on immigrant rights over the last 4 years in particular. On the other hand, I will say that, we've seen some great lawyering occurring. And the wins that we've seen have been meaningful. And so to that extent, I know we at Indiana, this is something that we're really trying to encourage among our students to follow in the lead of these great advocates.
Thank you, Professor Krishnan. Professor Siegel?
Yeah, I mean, I'll pick up on that with the immigration example, because in some ways I think it so nicely illustrates both the ways we're succeeding in training people and the places we have a lot more work to do and a lot more space to go. I mean, it is our students and our general community of lawyers is engaged and sophisticated in rebellious lawyering, in cause lawyering, in strategic lawyering, and never more can you see that than, for example, that first weekend when the travel ban went into effect in the United States in the early Trump administration. I mean, if you're looking for a moment of inspiration in terms of social movements and lawyering coming together, working hand in hand to resist, that is a blueprint. That is a blueprint, and that is a high point. And many of our students and at all of our schools were involved in this and knew what to do and knew how to play a role, and many of our faculty did. On the other hand, as Professor Krishnan points out, it still has been a brutal 4 years, 5 years in the immigration space. Early victories are lost at court or negotiated away. More subtle things happen, more brutal things happen, more carefully hidden from view or protected from judicial review. And forces of oppression continue their slow and steady march there. And I do think that we could do a better job preparing our students for the slog, right? Not just for the highlights, not just for the big, not just for the big moments, but kind of for what it means, not just in terms of lawyering skills, but in terms of personal skills and personal wellness and things like that, to be living in the life of resistance. There's a great literature on kind of the toll it takes and the personality steps you have to take to participate in that life, written primarily through the literature of career public defenders, but it's extrapolatable to other areas as well. And that kind of preparation law schools could do more for.
Thank you, Professor Siegel. Professor Ukey, you will have just 2 minutes to wrap up, and after that, I really need to hand over the mic to Srijit, who is already there. Yes.
In response to the first question, I think that the issue of climate change. One or the other day, all the nations keeping aside their own self-interest, as well as their own kind of the agenda, they need to come together, because this earth is to be preserved for future generations, though not now, at one or the other point of time. So that will be the common cause rather. In response to the second question, yes, the legal institutions, law schools, they organize and particularly the clinical legal education movement. I call it as a movement, and clinical legal education movement, that is one area. And even clinical legal aids, free legal aids, and camps, even particularly even slums as well as rural areas, whereby students learn and they get connected with the society, with the masses, So from this perspective, there could be a kind of a social lawyering as such when we talk about it as such. So these are the two things, and these are the two responses from my side. Thank you.
Thank you, esteemed panelists. This has been a fantastic, fascinating session, and I'm really grateful to all of you to sticking to time.